Marco, how are you?
Good. How are you, Maya?
I'm fine, thank you, and very happy to see you. It's your first interview for my YouTube channel, Lawbreak. So I'm really excited to have you as a guest on my channel, Marco. Welcome to
Uh,
Lawbreak.
Thank you. I'm happy to always participate in your activities. This is a lot of work that you put into all of these things. I know from doing the Law Garage for 2 seasons that taking the time to find guests and topics and doing this sort of work that's basically free work is a lot and time consuming, but it's very important. And I saw your interview with Allison Craig last week, which was really good. And it's important that these issues get discussed. And you're doing a lot of great work here, so I'm happy to be here. I'm very honored to be here, really.
Oh, I'm very happy. Thank you very much for the very nice words. I didn't tell you to say anything, so it's like really very nice to have genuine.
I'll send you the bill later.
So thank you so much, and thank you for watching. And just on that interview, it was a really good interview and a very important discussion. And
Mhm.
we're not talking about the same topic, but on something that's also kind of similar in the sense that we're going to be talking about the role of the defense lawyer and how practice management impacts the role of the defense lawyer because we're now seeing that the police are a bit in hot waters,
Mhm.
but the thing is, the reality is, as defense lawyers, we've been feeling that the defense lawyer has been under attack by the public, the government in general, and we just feel like whether it's the changes to the law or even the public perception hasn't been very much in our favor. And um, I think it's a little bit unfair. So you're going to be telling us about that. Uh, what is your view about the role of the criminal defense lawyer, Marco?
I think this is a very multifaceted topic to get into because, historically, the role of the defense lawyer was a very important part of our society, and it still is. But historically, it was viewed as a very prestigious and honorable position because, we stand between people accused of a crime and the state's prosecution of them, and whether or not we hold the state to their burden. So that's our fundamental role here. But I feel like in recent years, and I don't know if it's a function of the law and how the changes in the law have kind of shifted um, in many ways to, for instance, let me just think of a few. Like there's a lot of commentary about 11B and how people get off on quote unquote technicalities with the 11B. There's a lot of discussion about defense counsel and the way we were historically perceived to attack complainants in sexual assault cases. So then the law changed around that. There's always this idea that what the defense does in defending their client and applying the law forces the government to then respond with changes to the law. Now the hot topic is bail, and there's too many people being released on bail. Well, people are being released on bail because really, if we look at it, defense counsel are putting together plans that meet the standard that has been articulated by parliament, and have we persuade justices and judges to release people on bail because we have plans in place that are legal and they meet the legal standard.
Oh, just
So it always, sorry, go ahead.
on that though, I mean, it's not just that, it's that the presumption should be released. I mean, we keep forgetting that people should be released at that stage. They're not yet convicted or
Mhm.
found guilty. So the norm, the majority should be released. It should be an exception that people are like, I'm surprised that there aren't too many more people who are being released. So the fact that people are shocked that some people are being released is actually shows that there is a misunderstanding of bail.
Right. And what happens is, and I feel that's been happening is that it's a look towards us as we are getting people released on bail. Well, we are applying the law. The law is that
Well,
there's a presumption
exactly.
of release.
So
The
that
law is that here, if they need a surety, here's a plan. If they need a put down a cash bail, then here's the cash bail. Like advocate for our clients' release, and we persuade courts to have our clients released. And so, because we do this, then we're we're perceived to be quote unquote the bad people in the system. And the other side of it is the defense are the only people who can talk about this. Crown attorneys don't come on podcasts and advocate the crown's positions or stand up in court or stand up and say why they've taken various positions um, on guilty pleas, on
and judges
issues with
can't
their
talk.
case.
Judges can't
And the
talk
judges,
either.
yeah, the judges are they've come out a lot more now, and you'll see. And as you know, we've seen some of the younger judges have come out. They've spoken a little bit more in terms of nothing controversial, but they're talking more publicly, at least in terms of education and in social media and some social media posts and so on. But the reality is the judges can't talk either. They can't stand up and say, look, and defend the justice system. And so it all falls on us to do it. And when we are looked to be on the wrong side of the equation and publicly advocating for positions that what Parliament is looking at and legislation is looking at as part of the problem. So we have to have stricter laws and we have to do this and we have to do that. And then the flip side of it is that we get to this point where now what? Defense lawyers are not getting appointed as judges, right? Like, and like I said, if you really read the bios of all the last, several judicial appointments, especially at the provincial court level, even though they've all come from the Crown's office, a lot of them have experience as defense counsel at some point. But it has come to the point now where if you really want to be a judge, if that's something you really want to do and you're a defense lawyer, then you should hang up and close your doors and apply to become a Crown for a bit
Yeah.
because they are only appointing from that side. And it's absurd, right? It's absurd that a qualified candidate is being prejudiced because they work for the defense. And so, in order for a qualified candidate to get the job, they have to do their time in the Crown's office. That's how it appears. Whether that's true or not, I don't know. I'm not in the background there, but I mean, you can just read the bios of the judges, and they all, if they're not lifelong Crowns, they all have some Crown experience or being appointed from the Crown side.
Right. And
What does that say about the defense counsel?
well, it also
Right.
seems like you have to be uh, like working with the government on the government side and going with the policies of the government for you to get appointed. Because if you're a crown, I mean, chances are you're abiding by the policies and the government, what the government wants. And so if you're a defense counsel, especially, I mean, as you mentioned, defense lawyers tend to be more active on social media. They're more outspoken. They do express their views. And some lawyers, more than others, are more vocal and they do express their political views. And obviously, if they don't coincide with what the government policies are, like if the government wants stricter bail, well, obviously they're not going to nominate someone who overtly criticizes that. So it is a bit of a challenge for a defense lawyer because some defense lawyers are entitled to have their opinions. And our job, ironically, our job is to criticize or to attack the government when they do something wrong. I mean, we're constantly opposing police action when there are charter violations. It's what we do. This is the nature of what we do, and yet we get criticized for doing that.
Well, the question I have, and the real concern I have is this. If you are a defense lawyer who who has judicial aspirations and are hoping one day to be appointed, are you going to alter the way you defend the person, the challenges that you bring, the the charter attacks on police? Are you gonna are you going to change how you do that because you think, well, if I argue this controversial position, or if I, bring this attack, or if I do this controversial thing, it could jeopardize my position personally, and maybe interfere with my ability to get appointed as a judge. And that's a concern. That is an underlying quiet way of silencing the defense.
Right.
It's the government saying, if you want to be a judge, like all the points you just raised, if you want to be a judge, we don't want anybody who's going to be, overly critical of the government, both social media side, even in terms of the way they conduct themselves in the defense of their client,
Mhm.
right? And then at that point, what are we doing here? Are we defending our clients to the extent of the law? Are we pushing the defense that we believe is the right thing to do, or are we going to quiet ourselves down because of fear that doing this could impact us on a personal, professional level? So, and this is where that interference, I see it as being a big interference into the defense bar is. And so I know we said we are going to talk a little bit about the way we manage a practice, but it all kind of intertwines because we are the ones who are, for instance, if there's a delay issue, or if our schedule comes into interfere with the court schedule and something, that we have to then take our clients' rights, get a waiver of our clients' rights in order to comply with our schedule. So it kind of puts us at odds with our clients in order to waive their 11B rights to comply with our schedule. So we're the ones who are always asked to make certain compromises as the defense bar. And it becomes concerning to me is at what point are our personal professional position going to are going to interfere with our clients' rights? And that's what I'm starting to get concerned, that the court and the system and everything is just kind of working against us in that way as the defense bar. And at some point, it's going to spill over,
Mhm.
right? And like there's overworked defense. Like if
Yeah.
a defense lawyer is overworked or stressed out or burnt out, then they're not going to do a good job in court.
But the
And if
reality,
they don't do a good job, they're going to get in trouble.
and Marco, to be honest, I don't know any defense lawyer right now who's not overworked, who's not bombarded with work. Everyone I know, including myself, we're just overwhelmed. There's just so much work. Whether you're working on your own, like me, or you're in a firm, even those who are in a firm complain about the same thing. There's too much work, and there's always pressure on the defense. Like we have to accommodate, we have to make time. It's always, well, if you don't do that, then you have to waive 11B, as you mentioned.
That's right.
And we don't hear the same type of reaction with the crowns. Yet crowns have vacations. Like for us, we don't have as many vacations as the crowns do. We don't get paid for like all these extra appearances sometimes that we have to make. We don't get paid for everything, especially if we're working on a legal aid file. You're not going to
Mhm.
get paid for every single thing that you do. So it's just putting the defense lawyer in a very difficult situation. And what I find is disappointing is that nobody seems to care. Like the public doesn't seem to,
Mhm.
it's like, well, who cares about them? Like it's not our problem. And I find that infuriating. I don't know about you, but it's infuriating and insulting.
Right. And, like we could be here, this could be a Crown podcast, and the Crowns can say the exact same thing because they are bogged down, they are overworked, they are, um, you know, obviously if we're overworked, they're overworked. If there's this many people in the system, then there's this many people in the system for both sides and for the court and for the system itself. I think that where the difference lies is we are the only party that's accountable to our clients and that could impact our professional capabilities. So for instance, if a crown, you know, hypothetically botches a prosecution and it results in a wrongful acquittal, if that happens, yes, I'm sure there's some accountability, but they don't run the risk of losing their job or their livelihood.
Right.
Whereas if as defense counsel, you can be found negligent, you can be found ineffective, you could be sued. You might have to engage law pro, you have to engage insurance. Like there's all these other aspects that impact us on a different level. So our ability to mess up impacts us a lot more personally and adds to a certain level of stress on top of us. And it's this in because of that, there's this implicit criticism from the coming from the bench or from the other side that anytime we do something wrong or make a mistake, well, the experienced counsel, it would have to be deliberate. And you cannot stand up in front of a court and say, well, the reason why I made this mistake is just because I'm overwhelmed, overworked, and I just dropped the ball here. You can't say that. That's for sure, right? I mean, you can, I guess,
I
but I
think
mean,
we
most people
no.
won't.
I disagree. I think we should. I think the problem is that we're not reminding them that there is an imbalance in the resources of the two sides. There is a huge imbalance, and that's the reason why we are in this crisis because we're not at the same level. Even lawyers who operate in a firm, they still don't have the resources that crowns have. So they still are many criminal defense lawyers are disadvantaged and they are expected to be prepared, to be on time, to have everything ready when they're facing the government employees. I also want to add something, Marco. One thing that you mentioned that crowns are also overworked because if there are that many cases in the system, they're also dealing with them. I think there is a problem here that we've been seeing recently. The difference between us and the crowns, crowns have more power, they have discretion. They can make many of these cases that are in the system go away. There are lots of cases, I think you will agree, that are really stupid cases. They shouldn't be taking that much time in the system. Some of them can be resolved by way of a peace bond or even with a plea without. And we often find ourselves in court arguing over silly cases that shouldn't be in the system. And crowns have the discretion to make them go away. But there's also, again, policies that they have to prosecute almost everything. And that's adding to the problem. Like if there are too many cases and that's causing all the delay problems? Well, one way is to get rid of many of the cases that we have. Not everything has to be prosecuted, even if technically, yes, there is a crime that was committed, but some crimes are really minor. Do we need to waste that much time, money, resources, and energy on everything? Not everything is a murder or a drug trafficking case. Why are we wasting so much time? And there has to be, I think, a change in the Crown office's culture.
Well, yes. It's an interesting. No, I always think about this. It's let's go to this proposition here that it appears that a lot of people want to become judges, right? Like if we start with that as a small example, if that is the goal of many people in the system, particularly many people who work for the Crown's office, right?
Hmm.
Then until they abandon that as their aspiration, aren't they going to toe the party line to a certain extent so that they can keep their professional reputation intact for that application? And I'm not saying that by doing that they're doing anything wrong. I'm saying if you have to exercise your discretion, aren't you going to exercise your discretion to um, proceed on matters that have a reasonable prospect of conviction? Because you know that is the easiest and most secure course of action. Well, there's a reasonable prospect of conviction, so I'm going to proceed on this. And rather than dig down and try to find some way to not proceed on it, that then you might feel some blowback. Like the Crown attorneys who take those steps to actually do that are the ones that have more of an appreciation of the system as a whole and what's required to kind of move matters along, and are at a point either in their career or for whatever personal reasons where they're not looking to, you know, like they're not looking to pad a resume or build a resume or do that. And the problem is there's less and less of those people because
Yeah.
they're getting to retirement age. They are retiring. And so these, the younger population of crown attorneys who still have a whole career ahead of them are less, in my, opinion, more likely to just do the thing of prosecute a case and, let a judge decide. And basically, I don't want to be on the hook for making this sort of discretionary decision. While I don't see anything wrong with that on a, on a like an ethical basis, because they're perfectly entitled to do that, it's very short-sighted in terms of the impact that it has on the system as a whole. And so, when judges in a JPT say to a crown, like, this is really, are you really going to prosecute this? This is really a waste of time. This is really X. This is really Y. And the crowns are like, well, I have reasonable prospect of conviction, and they proceed. It's like, they're not being bullied the way they once were. When I was a younger lawyer, a judge would say that in a pretrial. That crown attorney would then go up the ladder and say, Justice so and so said this. They don't think there's any merit here. I know we have RPC, but really, like, I don't think this case is going anywhere. And they would advocate to their superiors to have a case thrown out. Whereas I don't see that happening anymore in the same way.
Yeah.
And until we get close to the day of trial, and then closer to the day of trial, you might get offered a peace bond. You might get offered something. You might get offered a careless, on an impaired, etc. The problem is, and what I think a lot of people, and what the real issue then becomes is, A, the system is overburdened in that respect, and B, it's the resources of the client that are being expended to the 11th hour to get to a trial, to then have an offer put to them where inevitably, and I've had clients say to this, or maybe shift the blame to me and say, well, why weren't you able to secure this deal 6 months
Yeah.
ago, 8 months ago?
Yeah.
Why did I have to pay for you to do charter applications? Because then they make you feel like, oh, well, you did this. You made me do all this work. Or you made me pay for all this work in order to get this resolution at the 11th hour. And
Mhm.
it's not my fault. And I try to tell clients early on, like, look, it's unlikely that this is going to resolve until they see the whites of our eyes and that we're ready to go to trial, get there and do that. So, when we talk about and shifting it to the practice management side, because this is a good segue into that, a lot of this, if we want to change a bit of our perception in society, it's being more candid with clients about how the system actually works, right? When you have clients who are not familiar with the justice system, first time offenders, middle class people, they come in and they're shocked that they're going to wait 18 months for a trial.
Yeah.
They're shocked that, oh, and I see on the news that drug dealers are getting cases thrown out, rapists are getting cases thrown out, and I have to go to trial on this, domestic assault where my wife doesn't even want to prosecute. And you have to claw them back and say, what you're seeing in the media is not an accurate representation of what's happening in our justice system. Right now, you're going to go through it, and now you're going to understand it. And I try to explain to them, you know, same things that we're talking about here. Don't expect a crown attorney to just jump and pull your case. You're one of 200 files,
Mhm.
and frankly, they don't care, like, about you. We're going to try to advocate as much as we can, but there's a good chance that this case is going to go ahead. There's a good chance that you might not get this deal until the day of trial, if at all. And unfortunately, you're going to have to pay for the work that's done up to that point. So I prepare them early. I really do. I prepare them early for that, uh, because I don't want them to come at the day of trial and accuse me of basically dragging it out for retainer purposes in order to get a deal that I could have got. Because that's my biggest concern,
Yeah.
right? And crown attorneys don't seem to appreciate that. So what I've started to do is, if I think a case is resolvable, let's say by way of a peace bond, or if it's an impaired and I see various charter issues, I will send the emails to the crown and I say, in my obligation to preserve my client's resources, I'd like you to consider the following and articulate why I think, because that way I can present to the client at some point later if they accuse me of running. I'm saying, look, I've been telling, look, I sent an email on this day, sent an email on this day, I sent an email on this day, and it's always in an attempt to preserve your resources. I'm not here to waste your money or
Mhm.
to run up your bill. I'm here to advocate for you. And if I can get the matter resolved in 30 hours of work rather than 60 hours of work, and I have an obligation to do that. And I think we have to educate our clients in that way so that they know that you're working for them for the money that they're providing you and not looking to run up a bill and getting a deal. Because we know you might get a deal on a terrible case. We know you might get offered a careless on the day of trial if you file a good charter and you have good charter arguments. But we also know that no one's going to offer you that deal until you file the charter. No one's going to offer you that deal until you do that. So you have to walk the client through that, all the steps of the process, and say, this is what we're doing. This is how we're playing, using your resources. And this is how we're going to try to get the result that we want. And ultimately, it'll be your decision to decide that. But it all comes together in your office beforehand, explaining all of these issues that we are discussing. And when they say, "Well, I don't understand," like, why won't anybody look at this earlier? And because you have to explain to them. I don't know. I don't know what goes on in their office.
Okay, sorry. I do want to interrupt here on this point, but the clients do have a point because if the same case is resolvable on the day of trial or later in the day, why don't the problem, I think, also comes back to the crowns. They bear responsibility here and they need to care more about what they're doing and not just about, the outcome or, that's the problem because there were crowns. You mentioned that many of them are retiring now, but there was a time where there were crowns. If you give them, you explain to them, like I will sometimes, when I see that there are some issues in a case, I'll prepare a memo and put it in writing and explain to the crown. And when they read it, and if it's a reasonable crown, they'll say, yes, you're right, I agree. And I do see all these problems. And they will seriously talk to their management or higher ups and try to resolve. There has to be also, it's not just us trying to, explain to the clients and defend ourselves, because the problem is, all again, it comes back to there's a problem not just on the crown side as well, which I find is happening more now than it used to before. They need to also care and they need to care about, like the fact that if a case is resolvable, why do we need to drag it? Like we shouldn't be getting to
Well,
that point.
there's been more changes. Like, for instance, like, complainants have had more say now than ever. Start there,
Yeah.
right? Complainants have had more say. So before, whereas before, Crown used to look at it and be like, I don't, they might have made a credibility assessment on a complainant, right? They might have, you might in a sex assault case where you had damaging text messages or certain things, like that might be enough to get a Crown to pull a case, right? Because they know that, but now they don't have that, right? Now they have to, well, obviously there's a whole procedure in that, and alerting, it's basically protected the crowns because now the complainants have their own counsel. So their own counsel step in, and I've never seen a complainant's counsel walk over to the crown and say, well, in light of these 278 materials, we'd ask you to withdraw the charge. Like, that's never happened,
Yeah.
right? Whereas crowns used to do that before. They used to exercise that discretion if you had something compelling like that. So yeah, they are also. I'm reluctant. I agree with you. It's easy for us to always criticize. I think we had this conversation the last time I was on one of your
Yeah.
shows because you and I see this from a different perspective. And it's not that your perspective is not valid. It's 100% valid. I'm trying to always sympathize with the position of the crown attorneys because if you factor in the vast majority of crown attorneys, their level of seniority, their marching orders that they have, the limitations on their discretion, which is not unfettered, and then the fact that they have to go upstairs with any sort of resolution that might be really beneficial. All of those factors in an overbogged system militate in favor of saying it's too much, just run it. just run it. Like all of those factors militate in favor of a just run it, as opposed to let's get rid of it early. Whereas before there was this an idea of like, let's get rid of it early. Now everything is in altogether working in that way. And, you know, my biggest pet peeve, your pet peeve is that, but my biggest pet peeve is I don't receive crown materials until the day of trial or the day before on any
Yeah.
in the provincial court on any
Yeah.
application. All right. And maybe that's just my own personal unique experience,
No.
but I know it's not based on the tone and annoyance that I hear from the bench, because then the judge is like, well, I'm going to need an hour to review the materials that I just received this morning. And when you hear that, it's what are you supposed to say? Well, okay, we want an adjournment. Then you're playing the 11B game if you get the adjournment on that basis. So, okay, fine. Maybe you get the 11B, maybe you don't. But the client who's got a meritorious defense, who wants his trial, might say, just let's get this done. I've been waiting. I've been waiting X amount of time to have a trial. I don't want a delay. I don't want to run the risk of having a delay argument. And those, guess what? Those
And
11Bs,
then,
they're
and
not
then you
cheap.
want to be able to properly defend them. You can't just go ahead
That's
if
right.
they're going to file, because if the materials are filed, then you have to review them. You can't just be like, well,
Right.
I'm going to do this, even though I haven't had a chance to properly review the materials. So again, it puts a lot of pressure. But why
Yeah.
are they delayed though? Like, why
Well,
are
that's what I don't understand.
But
I,
that's the thing. Like there has to be a change in their culture. Why are they delayed? They have an office. Why can't they manage to bring their materials on time? And on this delay, I'm fine if they're delayed a day or two or three. That's fine. We do that. We allow that margin for each other. But sometimes, like you said, either there's no materials at all, or they arrive on the day of or just a few days before. And that is so unfair because crowns are not like defense, like, and it's frustrating and it's happening more and more. I see it in the East region. You're in Toronto, and that shouldn't be. I know you're trying to be cautious when you talk about the crowns, but I feel like there is an issue. Some of our problems are not just because of us or the clients or the public opinion. There's a lot of pressure coming because crowns are not doing things like they used to before. And it's having an impact on the entire system, I find. And it's unfortunate because there has to be a change in this culture. And I don't know if it's like you said, that this obsession that everyone has with becoming a judge, that is having an impact on how people are doing their current role.
well, I don't know if it's an obsession that everybody becomes a judge. I just think that some people have certain aspirations, maybe especially early on in their career, and they want to keep that door open, right? So I can, understand why they may or may not advocate in a particular way or take certain positions or do certain things because they don't want to close any, or whatever they call it, career suicide or whatever, at an early stage in their careers. And I look, I know I've had crowns stand up in court. I was shocked. One crown, filed an application and it was a statement application without the transcript. And they just said, where's the transcript? And the crowd said, well, we're operating on a budget. And I kept my composure, but in my mind, I almost fell off my chair. I'm like, you're going to try to get a statement in without providing actually a transcript of the statement, just playing a video to the judge and asking the judge to determine without a transcript. But in any event, then the comment itself blew my mind.
Yeah.
But I agree with you that those sorts of comments and that's kind of ridiculous. I get that. My bigger problem is when that does happen, it is it is usually there's usually an expectation from the court that the defense is going to be able to play through. They'll look at you and be like, okay, well, can we proceed?
Yeah.
Unless it's something completely, I agree with you. We should have an opportunity to review, consider, decide, whatever. But instead, we are expected to play through.
Yeah.
And because we're expected to play through, then we need to be on the ball. We need to, and frankly, we have our clients to answer to. If our clients don't want an adjournment, right? If our clients don't want an adjournment, they want to have their trial, then they're going to ask you, can you realistically respond right now? Yes, I can. And so if I can respond right now, then the client's gonna say, okay, let's go. Whereas if it's something like, look, I can't, this is too complicated, I need more time, then you have to say to your client, look, I need to ask for an adjournment and I need an adjournment. But there's this expectation that the defense are always going to play through.
Yeah.
And that's what I don't love about the system right now. And so, we get, and I do want to talk about practice management, because the one good thing is we want to be on the side of file your materials on time. Because yes, there's some latitude, but when we miss deadlines, it seems to be the end of the world for the
Yes,
court.
I totally
When
agree.
the
Yeah.
Crowns miss deadlines, it's fine. It's an eye roll. The defense miss deadlines is the end of the world. It appears to be. Number one. So file your materials on time, get your instructions early, do your materials. And if there is going to be some reason for a late filing, notify everybody that there's a late filing. I think that for me, a late filing is not filing it on the day. If I miss it by a day or two, to me, that's a late. I consider that a late filing. But I would never consider bringing an application unless it's a new evidence, new disclosure, it's something unforeseen. I would never bring an application with closer than a day or two late, if unless I have to. So file on time. That's good. Get your instructions in advance, and discuss the retainer and discuss the process with the client, so that the client is aware that early on how the process works and how their resources are going to be allotted. Because it is very easy for the average person to look at the way the system works and think, did my lawyer run me up a bill to get a deal at the 11th hour? Right. And that's an easy common sense, especially, like from a first time client who's charged with something. They're thinking, why couldn't we resolve this long time ago?
Yeah.
Meanwhile, we had to do it here, and they did all this work that was all a waste of time because I got the deal on the day of trial. And so when you look at it from, especially people who come from piecework or labor work or work where they are the ones who understand, like, if I put in the time, if I'm building something, this is what it takes to build it. If I could have got it done in 2 hours and I charge the client 20, I'm ripping them off.
Mm.
That's how they look at us.
Yeah.
Right. And so you have to tell them this is how the system is working right now, and debunk
Mhm.
what's been put out there on the news. You have to debunk the media and the politicians and their elected officials, that many of the clients who don't believe the system works that way voted for these people. So they voted for these people. They voted for tough on crime and this and the bail. And then when their son, how come my son's not getting bail?
Yeah.
I thought it was catch and release.
Yeah.
Really?
Yeah.
Why would you get that idea? Right? It takes 3 days sometimes in Toronto to even be heard on a contested bail hearing.
Mm.
And they're shocked. I thought it was catch and release. Like it's you have to debunk all the publicity. And I feel like one client by client by client, the defense bar kind of wins those people over, and maybe their family members if they start listening or whatever. But at the end of the day, we are the ones and the only voice, public voice for the system, and we have to continue to do that by the way we manage ourselves. And the last point on that is the way we present ourselves publicly, right? If, your public image has a lot to do with, what you put out there in terms of this podcast and being vocal, and your posts on social media are about decisions that are important. That's the way you're promoting not just yourself, but the defense bar. When you see these American style advertisements or certain, inflammatory comments that are put out there simply just to generate traction,
Yeah.
it really does make the defense bar look bad. And then it sends a message to the general public that maybe we're all like that, and
Yeah.
that whole idea that we're getting people off on technicalities, it starts to you know permeate the public thought, and we have to resist that. We have to resist that a lot. And so I think that's an important thing. And that also goes to how you manage your firm, your practice, and conduct yourself publicly as a lawyer.
But I also feel, Marco, that sometimes, I mean, we still have some people who care about the profession. You're certainly one of them. Like I know from knowing you over the years that you're a defense lawyer, but you love being a defense lawyer. Like I never, when I talk to you, I never get any sense that you're a crown or that you're going to do
You're
something.
going to be shocked when my crown
Yeah.
application comes through.
Well, I'll be very disappointed if that happens. But I feel that you love the profession. I feel your passion for the profession. And this is why, like I have so much respect for you because you're a true defense lawyer. But I can't say that there are a lot of people who are like that in the profession. I mean, there are, but I find like some people or maybe they like it, but not enough. Like you really have to contribute. We have to fight for this profession because it is in a crisis right now, and we are the ones who have to defend it. Like for me, for example, I find it really disappointing when some defense lawyers say are happy, oh, the Crown said something good about us. Why should we wait for them to give us a better image? Or, I don't care. Like it's our job, it's our profession, it's our duty to defend it and to contribute and to do well for it and for others. Like I try on my level as much as I can to help and to promote, but I'm not enough. And there should be more people who are doing it for the profession. Like I find that's what we need. More people who actually care about the defense work, not their own image and name, and again, to use it to become president of something or, like a judge somewhere. Like again, this obsession with another job, a better position, sometimes affects how people work. And we don't have enough of the people who really care about the profession itself, like you. And there are other people who are like you as well, who are working and who are contributing for the right
But
reason.
it gets exhausting.
I know.
I can see why it's exhausting.
I
It
know.
is exhausting that at every turn, like there used to be this old judge, I'm not going to say who it is, but he used to say to me, whenever he used to see me, he used to say to me, I hope you're continuing to throw sands in the gears of justice, right? Like that, and like, throw sand in the gears of justice. That's fine. But if you look at the justice system as a machine and all the things are operating together, and you look at our role as being throwing sands in the gears to create this sort of friction, inevitably we're going to be disliked, right? Like we are in the way. We are causing a problem. The smooth operation of the justice system is being grinded by our sand that we keep throwing into the gears of justice. And now it's becoming to the point where I feel as though we are the irritants in the justice. Like we actually are the sand in the gears, and that everybody's always annoyed with us. They're annoyed with, oh, well, they're not prepared, or they're not, this, or they dropped the ball on that. And it's always the defense who's that, but we can only do so much. And so if that's your job and that's where you get up every day and that's how you go to work and that's what you feel when you go to court and that's what you feel from the judges and that's what you feel from the crowns, and then you get the added thing from your clients, and you get resistance when you go to the jail. Not to mention, I'm not going to get into what happened in the Durham Region Courthouse, but that's just another example. Or you get another crown in Manitoba gets put in to custody for a weekend, or you hear about defense counsel who gets cited in contempt of court for not filing memos. All of these things, that's your everyday life. Yeah, you know what? You know where I want to be? I could see a person waking up in the morning, go, I'm done with this. I want to be a crown. I'm done with this. I want to be a judge. I'm done with this. I want to go work in a different area of law because I can't deal with the constant tension that comes with my everyday life. And so, yeah, I really take it as a compliment to be called a true defense lawyer, but also like, I can see how grinding it is on your every being, every aspect of your life. And it's just like, this is the type of job where you really want to get in there and do it every single day, because if you don't have that, then there's better jobs out there. There really is.
But it's more difficult because there aren't enough of us who are doing this. I mean, if there were more, people who were doing this for the same reasons, for these reasons, for really helping and promoting the profession, it would be easier, I think. But it's just getting, and I understand, like it's like you said, it's a lot of work, it's very time consuming, and if you want to contribute not just by your work as a lawyer, but doing extra work, it's at your expense, right? You're giving out of your own time, your health, and everything. But if many of us did a little bit to contribute, then that would help, no? I mean, I think it would make it a bit easier.
It would, but then we add one more thing to it, the finance. It's not the most lucrative area of law, right? Especially for younger counsel who are taking on legally aided files, and the legal aid is not really paying. So then you add that element to it as well. So it's, I have to make a living. I have to do this. I have to do that. Then the government is putting in all these additional procedural hurdles. Take a sex assault case. It's going to cost, budgeting a sex assault case to a client is an art form now.
Yeah.
How much is oh, here's 4,000 text messages from our relationship. Okay, well, how do you want to pay for me to review these? Because it's like, now all of a sudden this has become a totally different type of job, because
Yeah.
that's 2 days in court just to even apply to get these messages in. At
Mhm.
least step one and then step two, and maybe a ruling day.
Yeah.
So before we even get to your trial, sir, you're gonna have a 3 days worth of litigation. Can you imagine before trial
Yeah.
on so that I can use evidence that
That in
is
any
relevant?
other case you can
That's
use.
right.
That's what's
That's
also,
right.
that's what I find insane is that if it was a domestic, you can use these messages. But
That's right. So a big part of the job is educating our clients, budgeting,
yeah,
figuring out how to put their, and then you risk letting a client walk out the door because of the retainer fee. But the reality is somebody's gonna hire they're gonna hire somebody who will do it within their budget. But if either they're going to do all this work and it's going to come out of the lawyer's pocket, or they're simply just not going to do enough of a job. So that's where we land here in the way the justice system is unfolding. And so eventually the toll gets taken on its lawyer, because if you don't do the work that's required, that might come back to haunt you in terms of the outcome on your client. If you do the work that's required, that comes back to haunt you in terms of your finances and what it's done to your practice. And so either way, you're the person when you're deciding to take on this client, whether it be on legal aid or on a modest retainer, or on a retainer that doesn't cover the work that's required, you're the in some way the lawyer is going to take a hit, whether it's in court or whether it's on the business side of things. And so that adds to the stress and it adds to the pressure. So we have all of these push and pull factors, and we're the only members of the criminal justice system that have those factors to consider all the time.
Mhm.
And so it's no wonder why you're right, this is a crisis point. This is a crisis point for us, right? And you can win a case, and you won it on a budget, and you almost have a certain resentment that you gave this guy his freedom, and you know you give him a deal too.
Yeah.
It's like, what's
Yeah.
your freedom worth? Well, 15% off because they couldn't afford the extra whatever, and they cut you short, right? So you get annoyed there. So it's like you're always kind of annoyed, you know?
Well, okay. But for, let's say, for younger or newer lawyers who are watching this, we
Mm.
don't want them to be discouraged, right? We want more people to come into the profession because I don't feel like this is very optimistic, and I like to be optimistic. I'm a bit naive, but I
Like,
like to be optimistic. I mean, we have to give people hope, though, Marco, about getting into the profession. Like, this is not to,
uh,
uh, you know, um, convince people otherwise. I mean, if we have something to tell them and encourage them, first of all, what I would say is care about the profession and do something. Even if you don't have to put a lot of time like I do, But, or like other people, I'm not the only one. There are a lot of people who are doing a lot of work also for free. But just do something that helps, because when you do something that helps, you're not just helping whatever, like a subject, you're helping the entire profession. So you have to care. I find sometimes what I find frustrating these days, and it's on all sides, not just defense lawyers, it's defense, crowns, even judges. I feel like there are a lot of people who care less. They just want to do the job, go home, and have the least minimum, like least headaches they can have in a day. So you have to care about the job, not just do the job, care. And it's how to ignite that passion in people that I think makes it much better, because even when you're dealing with the crown, like I'd rather just deal with someone who's really passionate, who really likes what they're doing, than with someone who just feels like a machine, just doing their job to end the day and just.
That's yeah, you're right. That is, and that's the look. You want to end on a good note here, so we're going to end
Yeah.
on a good note. But the reality is this: yes, everything I said of the difficulties of this job go away with the person who is passionate, who's here for the right reasons. Because you are going to be successful in this profession if you show up every day because you care, you put in the work, you you plow through when people are coming against you, you're prepared, you're you're doing everything you can to as a young lawyer, you when I was a young lawyer, I would work for free if I could, if a case was good enough. When I see young lawyers who want to take on a file that to me it's an absurd business decision, but it's because it's a good case, I'm like, no. Like you because ultimately the good case, it's good that you want it, but you have to look at it like how's it going to affect you and your ability to practice. If you're traveling or commuting far away and it's taking its toll on you and running you down and maybe impact the way you do your job. So you got to start making decisions that are right for your practice management, but it's wanting the good case that's important.
Mhm.
That's the difference. I want a good take. People when I get excited if somebody calls me and says, you want to come and help me on this murder. I know I'm not going to make a lot of money. I know it's a legal
Yeah.
aid case. I know we're going to have to split this, in some way. But if it's an interesting
Yeah.
case, I
Yeah.
want to do it.
Yeah.
So yeah, I'll take the haircut to do that case because that to me is what motivates me and drives me to be there and do that case, right? That's what you need. You need that motivation that I want to do a good case. If you're motivated by wanting to do a good case, then you're right for this job. If you don't have that motivation, if you're like you said, if you just like coming in, this guy's gonna plead, this guy's gonna do this guy's gonna you're motivated by other things that's not doing that good case, eventually the system's gonna break you. It's gonna break you either because of your competence, it's gonna break you because financially you're not gonna be able to withstand it. It's going to break you because the client's going to complain. It's just going to break you in some way. But when you're motivated to do a good case, that motivation and coming forward with that passion, that's what gets you.
Yeah.
And that is those people tend to be the people who join organizations, who help set up CPDs, who do podcasts, who speak to younger lawyers, who join the mentorship, who do all that thing because they want to be good lawyers,
Mhm.
right? Being a good lawyer first, and then once you're a good lawyer, once you know what you're doing, once you're a passionate advocate, kind of the rest of the system becomes much more tolerable, right? It just becomes much more tolerable, and it's less likely to break you, right? And that's where you need to put your best foot forward is I want to be a good lawyer first. If I'm a good lawyer first, everything else will fall into place. But if you're constantly focusing on all the negative things that we spoke about coming from a perspective of having done this for a long time and identifying the issues that we see, then yeah, we're going to discourage people from being like, I don't want to be part of this profession. But you will want to be part of it if being a good lawyer, defending people's rights, advocating for people is what brought you here. All the other stuff is going to kind of not really bother you because, especially when you're young, you want to get into that. You kind of want to get your hands dirty. And honestly, and I'm going to say this, it's going to be maybe controversial, but set your sights short term. I want to be a good lawyer. I want to make it to 3 years, and then at 3 years, I want to do this, and then 3 years. If you think in 3 year terms or 4 year terms, you're not thinking of being a judge. Being a judge is a far off thing. And if you decide after you've been a lawyer 20 years that you want to apply to become a judge, the career path behind you
Well, and
will
you
get you
can't
there.
even become a judge before 10 years in any event. So focus on being a good lawyer for the first 3 or 5 years. And then you can start thinking, obviously don't do something that's going to destroy your options of becoming, but you can still be a really good defense lawyer and have, like I mean, that judge thing, anyways, it's out of anyone's control. Nobody has control over it. What you can control is you, what you do, what you can bring to the profession. That is in a person's control, and they should focus on that. And again, on the passion thing, because I like people who are passionate about what they do. I like when someone does something because they really love it. Fine, of course, you want to make money. It's what we do full time. There's nothing wrong with that. And you can feel, you can't fake passion. You can't. Even if you talk and you say, when a person is really passionate, you can feel it. And if I want to think of all the people who are really known in any profession for what they do, what's common is that they all have a passion for what they do. I don't think all the big names in criminal law who are known are there, have been doing it without having been passionate about defending people. So I agree with you. This passion thing is really, really important, I think.
Mhm. And those are the people that we want to attract in the
Right.
profession. And look, I'll, I actually, having worked with a lot of younger lawyers, and I say younger, I mean, when I say younger, younger than me, but exp there is a lot of
Yeah.
passion
Yeah.
in this bar. There is a lot of passion in this bar. Actually, I don't really know the ones that are not passionate. They exist, obviously, but they just kind of don't come into my orbit because I feel like the people that, like, there's a certain orbit of people who are very passionate about this profession. We kind of bounce off each other into this world of like, we're here to fight the fight. You know what I mean? And the ones that are not in this orbit, they're really, they're more acquaintances or whatever. And I don't really feel that I associate very much with them. I feel like the ones that I associate with are the ones that are like-minded people who are hard, passionate, defense counsel who want to do jobs. And that doesn't mean they don't want to be judges. Maybe people do want to be judges at some point in their career. But it used to be that becoming a judge, your career spoke for itself. Now it's let me do everything right
Yeah.
now to build to get there. Whereas it used to be, I feel like it used to be the opposite. It
Mhm.
used to be they used to appoint people whose reputation as a lawyer like spoke for itself. They didn't make decisions getting there. I don't want to use the word political because it sounds like conservative and liberal. That's not what I mean. I'm just saying like, like what you were saying. Don't join an organization to pad your resume. Don't do this to like don't do things to pad your resume. Do things because you're passionate about it. And that passion is what pads your resume,
Yeah.
not the actual position,
Yeah.
right?
Yeah.
Like
No,
that's the thing. Do things and contribute out of passion, not out of potentially padding your resume.
and you
I agree
can't
with that.
fake it. You can't fake
Yeah,
it. Like people
exactly.
even your clients feel when you're passionate about what you do, your clients will tell you. They'll say, "I- Thank you so much for what you did today in court. Like you really did." Like your clients will feel it. People will
Yeah.
feel it. So,
Maya, I'm sorry that I came on here today on a glim note, but I think it was
well,
a good
it's fine.
discussion.
It's like the reality is that it's not very bright right now, but I like to be optimistic. I like to see, the light at the end of the tunnel. Hopefully things will get better. We're going through a difficult time, but it only means that things will get better. I hope. But it was very nice to have you as my guest for the first time on Law Break, Marco, and I hope it won't
Thank
be
you.
the last. I hope I'll see you again and we'll talk soon about other depressing subjects. So,
Thanks for having me, Maya.
no problem. Thank you, Marco.